Welcome to hopefully this is the final day of this trial. I know the first thing we were going to do this morning is talk about introduction of evidence. So I'll turn it over to whoever would like to start with that.
Yes, Your Honor. We've been working hard with the plaintiffs and the state defendants, and we appreciate all of the good efforts by all the parties. And so I believe we now have an agreement, and Ms. Moss will be moving into evidence certain documents. So Ms. Moss.
Good morning, Your Honor.
Good morning.
So the first exhibit that the legislative defendants would like to move in is LX 188A, and we put the A there as it's an amended version of the summary exhibit that we introduced through Ms. Strack. The court had allowed it in except for pages 3 and 4. We amended the exhibit to address concerns that plaintiffs have raised, and so now we're moving this amended version in its entirety, with my understanding, with plaintiffs there's no longer an objection to it, I guess.
LX 188A is received into evidence.
The next exhibit that we're moving in is LX 267, which is a redacted version of JX 798, which is the provisional voter spreadsheet that the spreadsheet itself is a highly confidential document, but we've applied redactions that the state defendants have requested. And so what we're moving in is basically a redacted version of JX 798.
LX 267.
Your Honor, plaintiffs would just like to note that this additional exhibit, LX 267, was not part of the deal with the parties, but because it is a joint exhibit, we have no objection to it coming in.
I'm not sure I understood that. Not part of the deal, but we don't object. Could you elaborate on that?
Plaintiffs would just like to make the note for the record, Your Honor. But because this is an original joint exhibit, plaintiffs have no objection to it coming into evidence.
LX 267 is received.
Okay. And then finally, we're moving in JX 942. And this is a new joint exhibit that's a compilation exhibit of reasonable impediment forms and papers made up of other joint exhibits, but we put them together into one, a compilation exhibit, JX 942.
GX 942 is received.
And then finally, there's a plaintiff's exhibit, but because it's a plaintiff's exhibit, I think that Mr. Simon should move that in.
All right, Mr. Simon.
Thank you, Ms. Moss, and thank you, Your Honor. Plaintiffs move in exhibit PX 139, which is a redacted spreadsheet of the 184 voters who cast a reasonable impediment declaration in the March 2016 primary.
PX 139 is received.
Thank you, Your Honor.
All right, is there any other exhibits to be received into evidence this morning?
Not from the legislative defendants, Your Honor.
Not from plaintiffs, Your Honor.
And so, Your Honor, just for the record, the legislative defendants rest their case in chief.
All right, just officially for the record, Mr. Cox, will there be evidence for the state defendants in this case?
No, Your Honor.
All right, and so now, just for the record, we're back at the point where we potentially would have been maybe yesterday or day before yesterday when we would have begun the plaintiff's rebuttal evidence. I hope you follow me on that. I think I'm right. And so this would be at the end of the plaintiff's evidence, and then at the end of the legislative defendant's evidence, and at the end of the state defendant's evidence. And so at this point, we officially would have begun the plaintiff's rebuttal evidence. We've already taken all of that rebuttal evidence order, but just to put it back in order, that's kind of what I'm trying to do now, is put that plaintiff's rebuttal evidence back in order that it would have been received right now, and plaintiffs would have then been in a position to rest their rebuttal case, which up to this point they actually haven't done. So, Mr. Riggs, I'll turn it over to you to address that.
Thank you, Your Honor. With the admission of the last plaintiff's exhibit that Mr. Simons took care of, plaintiffs rest their rebuttal case.
Very well. After the plaintiffs have rested their rebuttal case, is there any rebuttal evidence for any of the defendants, state or legislative defendants?
Not for the legislative defendants, Your Honor.
Not for the state defendants, Your Honor.
All right. If I were in a trial right now, I'd say, members of the jury, you've now heard all the evidence in this case. This is the phase of the trial for the lawyers to make their final arguments. Final arguments of lawyers. I got that memorized so well, and I would love to say it, but I would be preaching to the choir, as the old saying goes. Are you ready to give your final arguments?
Your Honor, may I just quickly address 2 housekeeping matters?
Yes, sir.
Number one, we've been in discussion with the plaintiffs and the state defendants, and we've all agreed with the court's permission that we would be able to and like to put in our findings of fact and conclusions of law 2 weeks from today. Would that be acceptable to the court?
That's very, very fine with me. Yes, sir. That's let's just put a date on that. Would that be May the 14th? Today's the 30th, isn't it? In 14 days.
Yes, Your Honor, that's correct.
Okay, so by Friday, May 14th at 5 o'clock, all parties will have their proposed findings of fact in the submitted to the court. Is that right?
Yes, Your Honor.
Okay.
And the second thing is I would just note that all of this has taken 7 minutes, and I took to heart the court's admonition last night that, sometimes less is more. And so I think we'll certainly be able to get through our closing in less than 100 minutes, Mr. Cox and I. But if we could have that much time, that would afford we'd still be able to take our 2 breaks. Ms. Riggs would have 100 minutes if she would like that. And so we just wanted to say that was our plan, to make sure that we take no longer than 100 minutes.
That's good. Thank you very much for that consolidation.
Okay.
Thank you very much for that.
That's it for the legislative defendants. Thank you.
All right. So, Ms. Riggs, do you wish to open and close the closing arguments?
In fact, Your Honor, it's my great pleasure to have my colleague, Mr. Brockman, present closing arguments on behalf of plaintiffs. But if you'll allow me a moment of personal privilege, thank you all for your time and attention this past 3 weeks. And I'll turn it over to Mr. Brockman.
You're very welcome. It's been a pleasure. Mr. Brockman, will you be opening and closing, or just doing the closing? I think.
Your Honors, I will present the closing and the rebuttal to the defendant's closing argument as well.
Okay, so you'd be reserving some of your time at the end then?
That's correct.
All right. You may proceed with your plaintiff's closing argument.
Thank you very much. Good morning, Your Honors. For the record, may it please the court, this is Paul Brockman on behalf of your plaintiffs, Jabari Holmes, Fred Culp, Daniel Smith, Brendan Pay, and Paul Kearney. First things first, plaintiffs would like to thank the court and the court staff very much for all the time and the effort that has gone into coordinating this remote trial. Thank you to Ms. Myers and to her team, to Ms. Fawcett, our intrepid court reporter, for sticking with us these past 3 weeks. We're very grateful for the opportunity we've been given to make our case in a way that's been safe for all of us and also open to the public. We also greatly appreciate the close attention that the court and your honors have given to this case and to the evidence presented during trial. At the outset of trial 3 weeks ago, my colleague, Ms. Riggs, told you that when the evidence was measured against the relevant legal standard, it would show that the state's voter ID law, Senate Bill 824, was enacted with the unconstitutional intent to target African-American voters. Now that the evidence has come in, we're confident that your honors will agree. I want to be clear at the outset about what that means and what this case is about. Plaintiffs acknowledge that a majority of voters in this state voted in favor of a constitutional amendment requiring photo ID for voting. We don't dispute that. We also don't dispute that some form of a voter ID law was necessary to implement that amendment. What this case is about is whether SB 824, the law that the General Assembly chose to enact, was enacted with the discriminatory intent to target African-American voters. The fact of the constitutional amendment alone cannot answer that question. The text of SB 824 was not on the ballot when voters approved the constitutional amendment, and the voters did not bless the substance of SB 824 by approving the constitutional amendment. Instead, we have to look to the totality of the facts and the circumstances around SB 824, and under the Arlington Heights factors, ask whether the evidence gives rise to an inference that the law was motivated in part by an intent to place barriers between African American voters and the ballot box. I want to pause on that standard for a moment. The question is not whether discrimination was the sole or even the primary motivation for SB 824, but whether it was a motivating factor. That's critical, and plaintiffs submit that the answer is yes. Here's why. First, history tells us that the legislature in this state has used facially neutral election laws like SB 824 to curb African American political power when it poses a threat to the party in control of the legislature. Make no mistake, this is not a guilty by historical association argument. But this historical evidence is important because it reveals a pattern of elected officials using laws to target African American voters when it is politically expedient to do so. Less than 5 years ago, the Federal Court of Appeals for the Fourth Circuit held that the state's last voter ID bill, House Bill 589, was enacted with a discriminatory intent because it followed that pattern. And we submit that SB 824 also fits that pattern, and that this is strong evidence of discriminatory intent. Second, the sequence of events that led to SB 824 and the legislative history of the law include many red flags that also raise inferences of discriminatory intent. In the summer of 2018, Republicans in the General Assembly understood that their supermajority was at risk in the upcoming fall election because they were likely to lose seats when racially gerrymandered districts were fairly redrawn. They responded by placing the voter ID constitutional amendment on the ballot, and the voters, as we acknowledge, approved that amendment in the fall elections. But the people of this state also elected enough Democrats in that election to break the Republican supermajority. And instead of allowing the people's newly elected and more bipartisan legislature to do the work of passing the new voter ID law, the Republican supermajority took the unprecedented step of rushing SB 824 through a lame duck session and enacted it over Governor Cooper's veto. That sequence of events suggests that they did so in order to enact a more restrictive voter ID bill rather than a watered down version that they assumed would pass with true bipartisan support in the 2019 legislature. The rushed process during the lame duck also left little time for true bipartisan debate, and the Republican supermajority rejected proposed amendments that would have been reasonably understood to benefit African American voters. Ramming SB 824 through the lame duck also meant there was no time to investigate concerns raised by Democrats that SB 824 would disproportionately burden African American voters, just as HB 589 had done. All of that supports the inference that discrimination was a motivating factor for SB 824. Third, the evidence shows that SB 824 does in fact bear more heavily on African American voters than white voters. African American voters are more likely than white voters to lack a form of ID that qualifies for voting under SB 824. As a result, they are more likely than white voters to have to jump through the additional hoops to obtain an ID, or more likely than white voters to have to vote using a provisional ballot. Taken together, the facts I've just described are compelling evidence that SB 824 was intended to entrench the Republican majority by targeting reliably Democratic African American voters. The Fourth Circuit enjoined HB 589 for that very same reason. It's also why the North Carolina Court of Appeals stopped SB 824 from going into effect at the preliminary injunction stage of this case. This court should permanently enjoin the law for the same reason. I also want to be clear at the outset about what plaintiffs are not required to prove. We're not required to come forward with outright admissions of impermissible racial motivation. Courts recognize that kind of smoking gun evidence is rare today because discrimination is more subtle than it once was. We're also not required to show that members of the General Assembly had racial hatred in their hearts when they enacted SB 824. It's enough to show that they used SB 824 to target African American voters because those voters vote reliably for Democrats, even in the absence of evidence of racial hatred. The court does not have to look into the hearts and minds of every single legislator who voted in favor of SB 824 and find them guilty of racism to find that SB 824 is still unconstitutional. The intent and motivation of any one individual legislator is not determinative here. Plaintiffs also are not required to show that SB 824 will actually disenfranchise African American voters if it is allowed to go into effect. The fact that African American voters may be able to overcome the barriers that SB 824 disproportionately places in their path does not mean that the law was not intended to target them in the first place. If it did, the legislature could openly pass intentionally discriminatory laws, no subterfuge, and get away with it just because the law did not perfectly achieve its discriminatory goals. That's simply not the law. Finally, we need not show that SB 824 is worse or as bad as prior discriminatory voting laws that this legislature has enacted. Much has been made at trial of the ways in which SB 824 allegedly improves on the design of HB 589. But the relevant question is not whether SB 824 is more or less discriminatory than HB 589, but whether it was intended to target African American voters. The evidence presented at trial clearly supports that conclusion. And I'll go through now the evidence as it pertains to the Arlington Heights factors and explain in a bit more detail why we believe that's true. I'll start with the historical evidence. The history of intentional discrimination against African American voters in this state runs deep, and it is not disputed. At the start of trial, counsel for legislative defendants called that history deeply lamentable and indeed shameful. We couldn't agree more. Plaintiffs' expert historians, Professor Anderson and Professor Louloudis, explained how and why this history matters. Professor Louloudis testified that the history shows a pattern. To paraphrase his testimony slightly, when minority citizens have gained political power, again and again, the party in power has moved to constrain their political participation, particularly when those minority voters pose a challenge to the governing party because of the way they reliably vote. Professor Louloudis testified that when African Americans gained political strength in the past, the legislature responded with things like poll taxes, literacy tests, bans on single-shot voting. Sometimes the rationale for these laws was trying to prevent voting fraud. Very familiar. All of these laws were facially neutral, just like SB 824. But all of them had the effect of targeting African American access to the ballot. Now, to be clear, plaintiffs are not claiming that SB 824 is as egregious as the poll tax or the literacy test. That's not the point. The point is that the historical pattern shows that the legislature knows how to use facially neutral laws to target African American voting strength when it is politically expedient to do so. The Fourth Circuit found that the General Assembly did that recently when it enacted HB 589. This is not ancient history. Professor Louloudis testified, and his report in this case explains that prior to HB 589's passage, African Americans were steadily becoming an increasingly powerful political force in state politics. He also explained how the Republican majority responded. After the Supreme Court gutted the Voting Rights Act in 2013, the Republican majority responded with HB 589. The law was facially neutral, just like this one, but the Fourth Circuit found that it was intended to target African American voters nevertheless. That history is not in dispute, and it shows two important things. One, that race and politics in North Carolina are closely linked, and two, that the party in power knows how to use election laws to target African American voters when it is politically expedient to do so. That is why the North Carolina Court of Appeals recognized at the preliminary injunction stage that the state's history provides support for plaintiffs' intentional discrimination claim. This court should reach the same conclusion. As I said, what I just described is not ancient history, and history didn't end with HB 589. The sequence of events that led to the enactment of SB 824 shows that SB 824 is in fact just the latest chapter in this history. The Fourth Circuit found that voting remained racially polarized in this state less than 10 years ago. That didn't end with HB 589 either. Professor Louloudis' expert report explains that voting is racially polarized in North Carolina in the modern era. The Fourth Circuit also found that racially polarized voting provided an incentive for Republicans to target African American voters and that the General Assembly that passed HB 589 understood that dynamic. Your Honors heard testimony at trial that 62 Republican members of the General Assembly who voted for HB 589 also voted for SB 824. It's simply implausible that these same Republican members of the General Assembly who understood the intersection of race and politics when they were considering HB 589 suddenly failed to grasp the incentives that exist to enact voting laws targeting African American voters when it came time to debate SB 824. The sequence of events also shows that the Republican supermajority had an incentive to target African American voting strength in 2018. Your Honors heard testimony from Senator Robinson about the effect of the Supreme Court's decision in the Covington case that was handed down in June of 2018. Senator Robinson explained that Covington meant that racially gerrymandered districts that had diluted African American voting strength had to be redrawn to more evenly distribute African American voters. And she testified that the statistics available to the General Assembly at the time showed that Democrats were expected to pick up seats in the legislature at the Republicans' expense as a result. Immediately after that decision was handed down, the Republican supermajority put the issue of voter ID on the agenda for the upcoming election. Senator Robinson testified that was no coincidence. She explained that voter ID became an issue after Covington because the Republican supermajority needed a way to retain its power. The sequence of events more than credibly supports Senator Robinson's view. Your Honors heard from legislative defendants' own expert, Professor Callanan, that the General Assembly knew HB 589 was dead nearly a year before it took up the issue of voter ID in June of 2018. That was when the Supreme Court denied cert in the McCrory case. The fact that the General Assembly waited until it became clear that racially gerrymandered districts would have to be redrawn is very telling. In fact, Professor Callanan testified that it would be rational to expect the Republican supermajority to try to shore up its control by targeting African American voters. I asked him on cross-examination if it would be rational for a party in control to want to entrench itself. He agreed they might. I asked him if it would be rational and expected for a party seeking to entrench itself to target African American voters if they voted reliably for the other party. And again, he agreed. As with HB 589, the Republican supermajority thus had an incentive to target African American voting strength in 2018, and that incentive supports an inference of intentional discrimination, just as it did in McCrory. The constitutional amendment does not sever this sequence of events, and it does not undermine the inference I just described. There's no dispute that the voters of this state voted in favor of some form of a photo ID requirement. But the constitutional amendment is not a silver bullet, because there's also no dispute that the substance of SB 824 was not placed before the voters on the ballot when they were considering the constitutional amendment. Voters were not even told the types of IDs that would be acceptable for voting if the constitutional amendment passed. If the legislature wanted to be absolved by the voters of this state, it could have and should have placed the substance of SB 824 on the ballot and let the voters decide. There's no reason why the legislature could not have done so. Its failure to do so should raise a red flag, because not putting the implementing legislation before the voters was a break from normal legislative practices. Your Honors heard testimony from plaintiff's expert Sabra Ferris on this point. Based on her long experience in the General Assembly, she testified it was atypical and, quote, not standard practice for the General Assembly not to put the voter ID legislation before the voters in connection with the constitutional amendment. And there are other departures from normal practices in the sequence of events leading to SB 824 that should raise other red flags. In the November 2018 election, the same one where voters approved the constitutional amendment, the people of this state also voted enough Republican legislators out of office to break the Republican supermajority. But the Republican supermajority did not allow the people's newly chosen legislature to take up the work of implementing the voter ID amendment. Instead, they convened in a lame duck and they rammed SB 824 through over Governor Cooper's veto. Ms. Ferris testified that this was also a break from normal legislative practices. Your Honors heard testimony that none of this actually broke any legislative rules, and that may well be true. And plaintiffs also acknowledged that the Fourth Circuit recently concluded that the legislative process leading to the enactment of SB 824 was normal. Few responses. First, a legislature doesn't have to break its own rules to engage in unusual procedures that can support an inference of intentional discrimination. Courts readily acknowledge that. Second, the Fourth Circuit didn't have the benefit of Ms. Ferry's testimony and her insights into the legislative process. Third, the Fourth Circuit's decision, of course, is not binding here, and so this court has the opportunity to draw its own conclusions about what inferences should be drawn from the legislature's decision to pass SB 824 in the lame duck. We submit that common sense should tell you that the Republican supermajority acted in the lame duck because it wanted to pass a version of voter ID that it knew would not attract the level of bipartisan support needed to override Governor Cooper's veto once the new legislature was seated in 2019. Legislative defendants expert Professor Callanan confirmed as much under cross-examination. I asked him if enacting SB 824 in the lame duck was an indication that the Republican supermajority did not want to pass what it considered a, quote, watered down version of voter ID. Professor Callanan agreed. I also asked Professor Callanan whether a voter ID law passed in 2019 once the new legislature was seated would have been more flexible and would have included more forms of qualifying ID. He agreed that was a reasonable counterfactual. These common sense inferences show that the Republican supermajority wasn't respecting the will of the voters when it enacted SB 824. It was pursuing its own policy preference for a more restrictive voter ID law. That's consistent with the conclusions that the Court of Appeals reached in this case at the preliminary injunction phase. The Court of Appeals held that the enactment of SB 824 was unusual in part because it was passed in a short time frame by a lame duck Republican supermajority that knew it would lose their supermajority status in 2019 because of seats lost during the 2018 midterm election. Professor Callanan thinks the Court of Appeals just got this wrong, but to credit Professor Callanan's testimony would require this court to reach a finding in direct conflict with the opinion from the Court of Appeals. And the Court of Appeals was correct to conclude that the unusual sequence of events leading to the enactment of SB 824 supports an inference of discriminatory intent. Plaintiffs would urge this court to do the same. The legislative history of SB 824 provides additional evidence that the law was enacted with the intent to target African American voters. Your Honors heard at trial that SB 824 was nothing like HB 589 because it was a bipartisan bill. That is the story that I fully expect defendants' counsel will continue to tell today. Legislative defendants emphasized statements from the Democrats, including Senator McKissick, Representative Harrison, thanking Republican leadership for their willingness to work across the aisle to improve the bill. But each of the Democratic members of the General Assembly who testified at this trial under oath told this court that SB 824 was not a bipartisan bill. Senator McKissick explained that it's customary to offer collegial comments during debate. But he also told Your Honors that a true bipartisan process would have included Democratic leadership in crafting SB 824 before it was introduced, rather than relegating Democrats to just running amendments in the hopes of improving a bad bill after the fact. And Senator McKissick also told you what he really thought of SB 824. He wasn't happy with it, and he couldn't support it, in part because of the potential for disenfranchisement of African American voters. Representative Harrison gave substantially similar testimony. She testified that members of the legislature might thank one another as a matter of decorum, but that does not make the bill bipartisan. She told Your Honors that SB 824 was, quote, a very partisan effort, and that as the minority party, the Democrats did not have a lot of influence. Senator Robinson also testified that SB 824 did not have bipartisan discussion, bipartisan development, or meaningful input from the Democrats. And legislator witnesses also testified that the legislative process for SB 824 was rushed, that it did not involve sufficient consideration of the issues, did not allow for sufficient debate or opportunity to improve the bill, and did not adequately account for the concerns and risks to minority voters. Now, I want to turn to Joel Ford, former Senator Joel Ford, who of course the court has heard a great deal about during this trial. You've heard a lot about what his sponsorship of SB 824 means. Legislative defendants point to this as evidence of bipartisanship. But Senator Ford admitted that at the time he chose to sponsor SB 824, he was, quote, hurt and disappointed by the way some Democrats had treated him. He was not caucusing with the Democrats because he had learned that some of them had worked against him in his primary, which he lost. He was considering switching parties. He'd endorsed a Republican candidate in a competitive Senate race, even though he knew Democrats were working as hard as they could to flip seats and break the supermajority. And by his own admission, he was, quote, a man without a party. His involvement does not signal a bipartisan process. We also heard at trial that SB 824 could not possibly have been intended to entrench Republicans or discriminate against African Americans because Joel Ford, an African American Democrat, would not have supported the bill if it did. But we also learned that SB 824 is not the bill that Joel Ford believed he was sponsoring and supporting. He testified that he agreed to sponsor SB 824 based on his understanding that the so-called free ID would be available to voters at every early voting site and every polling precinct on Election Day. SB 824 provides no such thing. We saw the state board rules, temporary and proposed permanent rule governing free ID that expressly state that free ID is not available on Election Day. We also saw in a previously confidential legislative email that staffers for the Republican leadership knew SB 824 would not make free ID available on Election Day, even after Senator Ford's amendment had been offered and accepted. Senator Ford may well have believed that the legislative process around SB 824 was collaborative and bipartisan, but he admitted that none of his Republican colleagues ever told him that SB 824 did not do what Senator Ford thought it did. The court also heard evidence that amendments to SB 824 sponsored by Democrats were accepted. We don't dispute that. That's also consistent with the testimony you heard from Senators Robinson and McKissick and from Representative Harrison that Democrats did what they could to improve the bill from their position in the minority party. But they also told you that bipartisan support for an amendment is not the same thing as a bipartisan bill. We'd also asked the court to consider the changes to SB 824 that the Republican supermajority rejected. Senator Robinson testified about a rejected amendment that would have extended early voting to the last Saturday prior to the election. She explained the amendment would have helped the African American community avoid disenfranchisement because the last Saturday before Election Day is, quote, a major day that our communities count on. The Republican supermajority also rejected efforts at the time to add public assistance IDs to the list of qualifying IDs for voting. The context for that decision is key. The District Court in McCrory found that removing public assistance IDs from HB 589 was particularly suspect because reasonable legislators could have surmised that African Americans would be more likely to possess those IDs. The Fourth Circuit specifically cited that finding in its opinion finding HB 589 intentionally discriminatory. And yet, with that finding fresh in mind, the General Assembly's decision to once again exclude those IDs must be viewed as particularly suspect. The fact that the legislature came back later after this lawsuit was filed and added public assistance IDs in HB 1169 doesn't change that. A subsequent bill can't negate the General Assembly's initial decision or speak to the legislature's initial intent. And the way that public assistance IDs were added after the fact should raise red flags of its own. Senator Robinson testified that HB 1169, the law that approved public assistance IDs, was a COVID-related bill that, quote, had nothing to do with voter ID. She described the insertion of public assistance provision as, quote, a sly amendment. That characterization is apt. Karen Brinson Bell, the director of the State Board of Elections, testified at her deposition that after HB 1169 passed, the State Board had not, up till that point, identified public assistance IDs that would actually qualify for voting. Why would the legislature go to the trouble of enacting a law that wouldn't add a single usable ID acceptable for voting? The most logical answer we submit is that the legislature understood that its initial decision was suspect and it wanted to correct the record after the fact. The court should also consider the legislative history of what the General Assembly did not do before passing SB 824. And again, context and history matter a great deal here. The Court of Appeals found at the preliminary injunction stage that it was unusual that SB 824 was enacted without further study of the law's effects on minority voters, notwithstanding the fact that HB 589 had been so recently struck down. That is a compelling common sense observation. Your Honors heard testimony that members of the legislature raised concerns during the debate on SB 824 about whether the new law would burden African American voters, just like HB 589 had done. Senator Robinson testified that the General Assembly was specifically on notice of the risk that SB 824 could disproportionately impact African American voters. But despite those concerns being raised, the General Assembly did not request data on the rates at which African Americans and white voters possessed forms of ID being considered for SB 824. And what that means is that the legislature did not know whether the new forms of ID that were added to SB 824 would actually reduce the racial disparity in ID possession that had been observed under HB 589. A legislature that was working to avoid repeating the mistakes of HB 589 in the past would have wanted that information, would have sought it out. But as you heard from Representative Harrison, the Republican supermajority just had no time for, quote, getting it right, despite being called out by the Fourth Circuit. The fact that SB 824 included a reasonable impediment provision doesn't excuse the legislature's failure to look at ID possession data, because the legislature also had before it evidence showing that the reasonable impediment provision from HB 589 was not the perfect failsafe that counsel for the defendants will make it out to be. Representative Harrison testified that the legislature received a presentation from former State Board Director Kim Strzok showing that reasonable impediment declarations had been rejected during the 2016 primary, and that many voters without ID in that primary election had not submitted a reasonable impediment declaration at all. The prior reasonable impediment provision had not protected every eligible voter, and the legislature knew it. Taken together, all of this legislative history shows that the Republican supermajority was either deliberately repeating the choices it made when it enacted HB 589, or actively refusing to investigate whether SB 824 was really likely to be a better and different bill. That evidence also provides a strong inference of discriminatory intent. The evidence presented at trial also clearly shows that SB 824 will bear more heavily on African American voters in multiple and sometimes overlapping ways. The relevant question is not whether SB 824 will actually succeed in disenfranchising African American voters, but whether it places more burdens on those voters. Professor Kevin Quinn testified that he investigated that question using a matching analysis to try to determine how many North Carolina voters lack a qualifying form of ID and whether those voters were more likely to be African American. He found thousands and thousands of voters who lacked ID and found that they were, in fact, disproportionately African American. Now, Professor Quinn, we admit, did not have access to data to allow him to conduct a matching analysis on every single form of ID covered by SB 824. We tried to get that data for him. Believe me, we tried. We wish we could have got it all. But Professor Quinn did have DMV data, which covers the most commonly held form of qualifying ID under SB 824. And he also had data on some of the new forms of ID covered by SB 824, including school IDs. His work shows that African American voters are nevertheless 39% more likely to lack forms of ID included in his matching analysis. And among those who voted in the 2016 and 2018 elections, African American voters are twice as likely to lack the forms of ID that Professor Quinn analyzed in his matching analysis. Let me be clear about what that means. Those percentages are relative to white voters. And we've heard a lot about whether that's the appropriate way to report this information or whether the ratios, the risk ratios that Professor Quinn used are misleading. But that risk ratio goes to the essential question that we're trying to ask and answer here. We're trying to figure out whether it's more likely that Black voters will lack a form of qualifying ID than white voters, and Professor Quinn's analysis speaks directly to that. Now, defendants have not presented a competing estimate of the racial disparity in ID possession rates. Their expert, Dr. Janet Thornton, did not conduct her own comprehensive matching analysis. She tries to poke holes in Professor Quinn's work, but she can't say for certain that there are no disparities in the rates at which African American and white voters hold qualifying forms of ID. And she certainly can't say with certainty that Professor Quinn's numbers are absolutely the wrong estimate. She has her criticisms, we believe that Professor Quinn's estimates hold up. Now, the legislative defendants told the court at the start of this trial that this figure, the risk ratio that Professor Quinn reports, is not informative because the same ratio could be found if even just a handful of voters lacked qualifying ID under SB 824, or if the percentage of Black and white voters who lacked qualifying ID were different. But we're not talking about just a handful of voters here. Professor Quinn's results speak to thousands and thousands of registered North Carolina voters who lack ID and who are disproportionately African American. These are real people whose right to vote is at risk under SB 824. Now, another attack on Professor Quinn is that the disparity he finds in his current report is narrower than the disparity he observed when he analyzed HB 589. That can't save SB 824 either. To begin with, the difference in the disparity may be illusory because, as Professor Quinn testified, it could be plausibly explained by passport data, federal ID data that he did not have access to in this case. But more fundamentally, the question is not whether SB 824 bears more or less heavily on African American voters than a different voter ID law, HB 589, but whether it bears more heavily on African American voters at all. Courts acknowledge that disparate impact need not be overwhelming to establish one of the circumstances evidencing discriminatory intent. And we submit that a finding that African American voters are 39% more likely than white voters to lack a qualifying ID is more than sufficient to meet that standard. Legislative Defendants Counsel may tell you that any measured disparity in ID possession rates is beside the point, since any voter can still vote by either obtaining a free ID or voting a reasonable impediment ballot. They made these exact arguments to the Court of Appeals at the preliminary injunction stage, and the Court of Appeals rejected them. This court should do the same. Just as we did during the preliminary injunction proceedings, plaintiffs have shown that the burdens associated with obtaining a free ID are likely to fall disproportionately on African American voters. African American voters are more likely than white voters to have to obtain a free ID because they are more likely to lack a form of qualifying ID in the first place. And African American voters are also more likely than white voters to have difficulty obtaining IDs because of socioeconomic disparities in the state. Professor Louloudis testified that African Americans are more likely to live in poverty than whites, more likely to be employed in low-wage jobs where they cannot afford to take time off, more likely to lack access to private transportation, and more likely to live in rural areas where public transportation is limited at best. All of this makes it more difficult for voters who lack an acceptable ID to obtain one, and all of these factors are more likely to bear on African American voters in North Carolina. These burdens are real. Your honors heard testimony from Elizabeth Holmes, that she would have to, the mother of one of our plaintiffs, Jabari Holmes, that she would have to pay for someone to take Jabari to go get a free ID. That's real dollars from a family that can hardly afford it. Jabari loves to vote in person. I'm sure your honors remember the demonstratives we saw where he expressed the passion that he has for voting, all despite his significant disabilities. Forcing a family like his to spend time and money obtaining a free ID is the kind of burden that will fall hardest on those who can least afford it. Simply showing up to the polls without an ID and voting a reasonable impediment ballot is also not a solution. Your honors heard testimony from Professor Ariel White, who explained that systems like the reasonable impediment process fail voters or can fail voters because there are multiple points of discretion where implicit bias and error can creep in. Professor White testified that data from the 2016 primary, when HB 589's reasonable impediment provision was in effect, shows that African American voters disproportionately encountered problems with the reasonable impediment process. She also testified that if African American voters are more likely to lack qualifying ID than white voters, they're also more likely to encounter those same problems at the polling place that could lead to disenfranchisement. This isn't just some hypothetical academic concern. Your honors heard testimony from two of our plaintiffs, Dan Smith and Paul Kearney. Both of them possess a form of qualifying ID under SB 824, but neither of them had that ID in 2016 when they went to vote, and their experiences are illustrative of what can happen when the reasonable impediment process fails. Dan Smith showed up to the polls with a temporary ID, having lost his permanent license. He should have been permitted to vote, but confused poll workers didn't accept his ID. Mr. Smith testified about the effect this had on him. He was frustrated and embarrassed to be pulled out of the voting line while poll workers tried to figure it out. And although he ultimately received a provisional ballot, not a reasonable impediment declaration, his vote did not count because he did not properly understand the steps necessary to cure that provisional ballot. Paul Kearney, another plaintiff, arrived at a polling place where he's voted for years and where he knew the poll workers, but he left his ID at home. Like Mr. Smith, he also received a provisional ballot instead of a reasonable impediment declaration. And his vote also did not count in the 2016 primary because that ballot was not cured. Your Honors also heard testimony from Kate Fellman, an experienced voter advocate who has interacted with thousands of voters across the state through her organization, You Can Vote. Ms. Fellman testified that the reasonable impediment process can be confusing and intimidating for voters. She also testified about how her conversations with members of the African American community have left her even more concerned about the deterrent effect of SB 824. As Ms. Fellman testified, a common refrain from community leaders is that laws like SB 824 simply send a signal that the state just does not want African American voters to vote. In sum, Your Honors, the evidence shows that SB 824 bears more heavily on African American voters in multiple ways. They are more likely to lack qualifying ID than white voters in the first instance, and they're thus more likely to have to jump through the hoops required to obtain an ID, or more likely to have to navigate the reasonable impediment process. Data from HB 589 tells us that when African American voters do engage with the reasonable impediment process, they may encounter problems, whether due to implicit bias or other factors. And the socioeconomic realities across the state mean that African American voters are more likely than white voters to confront additional barriers, such as poverty, lack of transportation, that make obtaining an ID challenging for those who do not already possess one. These impacts are real. Voters like our plaintiffs, you heard them testify, they value and take pride in casting their ballots. Under SB 824, the evidence shows that African American voters are more likely to face additional barriers to doing just that. Now, instead of really meaningfully confronting these burdens, the legislative defendants focus on the straw man of voter turnout. As I said before, that's simply the wrong metric. Plaintiffs are not obligated to prove that African American voting strength will go down under SB 824 in order to show that the law bears more heavily on African American voters. But in any case, the legislative defendants' assertion that African American turnout rates would not be impacted under SB 824 is pure speculation. The entire basis for that assertion is a paper by their expert, Professor Trey Hood, analyzing the effect of South Carolina's voter ID law. But Professor Hood admitted under cross-examination he had done no work to analyze this issue in North Carolina, and he provided no methodology to explain why his results in South Carolina would be likely to apply in North Carolina. The court should give his testimony no weight whatsoever. And even if the court is inclined to accept Professor Hood's methodology, he also admitted under cross-examination that when his study includes all eligible voters in South Carolina, it actually does show a negative impact on African American turnout. What we're left with then is evidence showing that African American voters, as I've said, are more likely than white voters to lack a form of qualifying ID, more likely to experience hardships that make it difficult to obtain an ID, and more likely to encounter difficulties navigating the reasonable impediment process due to implicit bias, human error, or both. Those collective impacts are more than sufficient to show that SB 824 bears more heavily on African American voters. And that evidence, combined with the General Assembly's history of using election laws to deliberately target African American voters, the legislature's decision in the aftermath of Covington to rush SB 824 through a lame duck session over Governor Cooper's veto, shows that discriminatory purpose was indeed a motivating factor behind the enactment of SB 824. In light of the evidence I've just described, we submit that the burden should shift to the defendants to demonstrate that SB 824 would have been enacted without discrimination as a motivating factor. The question is not whether the legislature had a rational basis for passing 824, but whether the General Assembly's actual justifications alone justify SB 824 in the form it was enacted. Defendants can't meet that burden. The Court of Appeals correctly determined at the preliminary injunction phase of this case that the need to implement the constitutional voter ID amendment alone cannot justify choices that the legislature made when it was enacting SB 824. The Republican supermajority was under no obligation to enact SB 824 during the lame duck. It did so because it did not want to pass a, quote, watered down version of voter ID. But a different, less restrictive voter ID law emerging from the 2019 legislature would have implemented the constitutional amendment all the same. The legislature didn't need to enact this voter ID law to achieve that purpose. The same is true for any purported interest the legislature had in deterring alleged voter fraud or promoting voter confidence. There's no dispute that in-person voter impersonation fraud is a vanishingly rare phenomenon in North Carolina. Defendant's own expert, Professor Callanan, admits that the evidence showing a connection between voter ID laws and enhanced voter confidence is murky and split at best. But the important takeaway is that a less restrictive law could have served both interests to the extent it would have served them at all. Any purported interest in preventing voter fraud or promoting confidence does not justify the particular requirements of SB 824. As in McCrory, the record shows that the problem the majority in the General Assembly was really seeking to remedy was emerging African American support for the minority party and growing African American political strength. That is all the evidence this court needs to conclude that SB 824 was enacted because of its discriminatory impact on African American voters and not in spite of it. Your Honors, as we told you that it would at the start of trial, the evidence in this case shows overwhelmingly that the Republican supermajority passed SB 824 to entrench itself using a voter ID law that would bear more heavily on African American voters. That is more than a sufficient basis to permanently enjoin this law. Plaintiffs respectfully ask the court to do so. The state's constitution demands it. I'll reserve the balance of my time.
All right, thank you, Mr. Brockman. I show, just for the record, that you started at 9:10 and it's about 9:53 right now, so I guess that's about 43 minutes or so. Mr. Thompson, who will be giving the closing on behalf of legislative defendants?
Good morning, Your Honor. I will.
All right. Do you want, I would hope that we could take a break around 10:15.
That's fine. I'm
means-
happy to do that. Yes, Your Honor.
That means we might interrupt your closing, but that breaks the morning up fairly well. You may proceed.
Thank you, Your Honors. And I'd like to start where Mr. Brockman did by thanking the court. This is our first Zoom trial, and the kindness, courtesy, patience that Your Honors and the entire administrative apparatus of the court has extended to us is deeply appreciated. So thank you very much for that. Your Honors, the sole issue in this case is the rationale behind SB 824. Why was it enacted? And here, we don't have to speculate about that. The voters of this state mandated that there would be a constitutional amendment requiring those who wish to vote that they shall present photographic identification before voting. And the plaintiffs made a decision not to challenge that constitutional amendment. And so that must be taken as valid, the amendment itself. And what that tells us is that photo ID itself is not incompatible with the North Carolina Constitution. The North Carolina Constitution is not at war with itself. Now, plaintiffs claim that this law, SB 824, was adopted with a racially discriminatory purpose. And specifically, it's very important, and Mr. Brockman reaffirmed this morning, what their theory is. Their theory is that Republicans intentionally targeted African-American voters to entrench themselves. And there are several undisputed facts that foreclose that argument. First, this is North Carolina's law. SB 824 is one of the most generous voter-friendly laws in the union. It has a sweeping, reasonable impediment provision that will allow any voter to vote. In fact, plaintiffs have not been able to find a single living voter in the entire state of North Carolina who will not be able to vote under this law. Now, we heard this morning for the first time an interesting twist, which was that, well, we as plaintiffs don't have to show that there would actually be a disparate impact. But they, at a minimum, the plaintiffs have to show that the legislator thought there was going to be a disparate impact. That's their theory. Their theory is this was passed. The motivation, the rationale was a motivation of entrenchment. And so they have to show that the legislator thought they were entrenching themselves. And when you have a reasonable impediment provision that allows everybody to vote who's a registered voter, and they can't find a single person ex ante or ex post who won't be able to vote under the law, you cannot infer that there was an intent to entrench themselves. Now, all agree that the General Assembly was required to have a photo ID law. And the evidence shows that the General Assembly chose a non-strict photo ID law. It was so generous that 20% of the Democrats in the North Carolina Senate voted for this when it was before the Senate. No political party would try to entrench themselves by passing one of the most sweeping, generous voter ID laws in the country. And no political party targeted with an entrenchment law would have 20% of its members of its caucus vote for the bill. SB 824 allows any registered voter to vote whether or not they have ID. It would literally be one of the least effective methods of entrenchment in the history of the United States. There are other dispositive and uncontested facts before the court. The law approves several forms of ID that were held by groups that predominantly supported Democrats. Take student IDs. They count under this law. Everybody knows that college students are more liberal than the general public. They support Democrats more than they support Republicans. Winston Churchill said, if you're 19 and not a socialist, you don't have a heart. And yet, the Republican legislator extended to the hundreds of thousands of North Carolina college students the right to have their college ID count. That's not the action of a legislature trying to entrench itself politically. The law also allows for free IDs. It mandates that those free IDs be available at one-stop voting polls. There's no additional cost to getting these free IDs because if you're already traveling to vote for one-stop voting, you can get it at the exact same time. And the record shows that everybody understood that African Americans disproportionately utilize one-stop voting. None of this squares with a political party trying to entrench itself. It's also uncontested that Democrats supported this law. It was sponsored by an African American, Joel Ford. He's a lifelong Democrat, and he wasn't the only Democrat to vote for this. Senator Davis voted for the version of the law that went to the governor. Senator Clark voted for the law on the second reading and was absent from later readings. Representative Hall voted to override the governor's veto, and Representative Goodman voted for the law on the third reading. All of them were Democrats, 4 of them were caucusing with Democrats, and 3 of them are African American Democrats. The plaintiffs would have you believe that either these 5 Democrats knowingly voted for a law that racially targeted African American voters, or they were duped into doing so. That's the only way you can rule in favor of the plaintiffs. You either have to find that these individuals were duped or that they intentionally attempted to target African American voters. And there's no evidence in this record that supports either one of those findings. Certainly Senator Ford wasn't duped. He testified compellingly. He had a job to do. The General Assembly was required to pass a law. And so he rolled up his sleeves and he did his job. And he also explained in compelling terms why he was supporting this law. He said he wanted to think about the least among us. I was thinking as a worst case scenario of an older Black woman who had worked as a domestic the majority of her life. And so one of my grandmothers actually did have ID, the other one didn't. And the last thing that I wanted to do was to support a piece of legislation that would have prevented them from voting. The last thing. It's also undisputed that plaintiffs don't have a scintilla of evidence, of direct evidence, of a racially discriminatory purpose. Their own witnesses have disclaimed it. Representative Harrison was asked, you can't say that you know that a majority of the General Assembly voted in favor of Senate Bill 824 for a racially discriminatory reason, correct? Answer, I cannot say that racial bias entered into it. And I would not say that racial bias entered into it. Senator Robinson made clear she wasn't speaking about the intent of individuals. Professor Harrison also disclaimed making statements about the intent to disenfranchise African Americans. Professor Louloudis said he didn't have the power to look into a lawmaker's heart. Professor White said she hadn't conducted an analysis of intent. And Ms. Fairs also made clear that she wasn't opining on intent. So they have no direct evidence, none whatsoever of direct evidence of intentional discrimination. So what they're asking this court to do is to infer that intent from a disparate impact of entrenching Republicans. The idea is that you infer the intent from the expected impact. Now, their analysis of impact is riddled with flaws, and I'll get to that later, but I want to start by accepting their evidence and showing why it can't possibly support the inference they seek to have you draw. First, we have the federal district court for the District of Columbia in the South Carolina case ruling that there is no disparate impact, none whatsoever, when you have a sweeping reasonable impediment provision like this one. In fact, this is more generous than South Carolina's. Second, the undisputed evidence is that the legislature did not look to the racial impact of this law. They didn't call for racial data about the number of students who would have these IDs or other people who would have these IDs. If you don't know the impact, it's awfully hard to infer intent from the impact. Plaintiffs suggest that it's nefarious that Republicans didn't call for the racial breakdowns, but a few points. First, there's no requirement for legislatures to call for evidence of what the impact racially may be of their legislation. And in fact, the General Assembly was criticized by the Fourth Circuit Court of Appeals in the McCrory case for having done so. Make no mistake, if the legislature had done so, they would be criticized in this case exactly as they were in McCrory. Second, any Democrat, Senator Robinson, Senator McKissick, could have asked for this data. They did not do so. Third, even if the data had been requested, it's impossible to know what the disparate impact is. Professor Quinn has been at this for 2 years. He still doesn't know what the disparate impact will be. Mr. Brockman said they tried desperately over the last 2 years to get the information. They haven't been able to get it. There's no way in which the General Assembly could have been able to figure this out if the plaintiffs haven't been able to with a statistical expert. There is a third reason you can't infer intent on this record. And Professor Louloudis explained that the relevant impact is on the number of people prevented from voting. I asked him, question, and the relevant disparate impact for the purpose of your report was whether these voters were going to be prevented from casting a ballot that would count, correct? And he answered, yes, barriers in their way. That's trial transcript 126 at lines 22 to 25 from April 13th. So according to Professor Laludis, you look at how many people can't vote, not how many people may or may not have a qualifying ID. It's undisputed in March of 2016, when the prior, less generous version of photo ID was in effect, that there was record turnout of 2.3 million voters. And at most, there were 184 reasonable impediment ballots that weren't counted. That's a minuscule number. And the General Assembly made sure that that number would be even lower going forward under SB 824. You cannot infer an intent to entrench a party based on a law that is known to have a minuscule effect, particularly when the legislature takes numerous steps to make that minuscule effect even smaller. And that's true even more so, given that most of the 184 ballots that were rejected were white ballots, not black. The plaintiffs have told you that African Americans are 39% more likely than whites not to have the IDs. And that's wrong and misleading for reasons I'll explain later. But even taken at face value, they cannot deny that more whites than blacks had their ballots rejected in the 184 ballots. And nor can they deny that more whites than blacks lack driver's license. Republicans cannot entrench themselves by enacting a law that at most invalidates a tiny number of potential Democratic ballots. And there are a couple of other flaws at the outset of plaintiff's case. Their arguments prove too much. Everything their counsel has told you today about the effect of SB 824 would apply to any voter ID law that was passed. And that's particularly true because they never suggest an array of photo IDs that would eliminate the disparate impact. Dr. Quinn said he didn't know of an array of photo IDs that, in his view, would eliminate the disparate impact. Under the North Carolina Constitution, a voter ID law must exist. So complaints and arguments that erect a test that no law may be able to meet are impermissible. Now, another thing we've heard today is an effort to stain SB 824 with HB 589. But if we look at a comparison of these laws, we'll see they are materially different. HB 589 was not constitutionally required. SB 824 is. HB 589 was omnibus legislation. SB 824 is not. Under HB 589, there were no student IDs, government employee IDs, public assistance IDs, and there were limited tribal IDs, and those all now count. There were no free IDs without documentation. Now there are free IDs without documentation available during one-stop voting. HB 589 did not extend voter ID provisions to absentee ballots. SB 824 does. HB 589 did not require aggressive outreach, educational. 824 does, for mailers to everyone in the state. There's no provision, there was no provision under HB 589 for a special ID if the DMV canceled, disqualified, or suspended. But now there is, even without application, the age under SB 824 for obtaining a free ID from the DMV was reduced from 70 to 17. And they lowered the age for voters to be able to use an expired form of ID from 70 to 65. These changes cannot be squared with their entrenchment theory of the case. The reasonable impediment provisions are materially different as well. 589 didn't have such a provision when it was enacted. Another feature of 589 is that it required reasonable impediments in obtaining the photo ID. SB 824 relaxed that to presenting. So that means that if you had a photo ID and you lost it, then you have a reasonable impediment under this law, whereas previously you did not. HB 589 required alternative identification to cast a reasonable impediment ballot. SB 824 does not. The county boards had wider discretion, and they have no discretion now. It has to be a unanimous vote finding falsity of a bipartisan committee. The provision allowing voters to challenge, there was a provision under 589 allowing a challenge. Now there no longer is. So the laws are very different indeed. I'd like to take a moment and address Jabari Holmes, and his circumstances elicit great sympathy. But the fact remains that under this law, he can vote. He can obtain a free ID. He can do that during early voting, so there's not an extra trip that's required. He can vote in person on election day, fill out a reasonable impediment ballot. He can vote absentee. And so Mr. Holmes can vote, and the challenges that he faces in voting come from his disability, not from his race. Plaintiffs pled a racial discrimination case, not a disability case, and they haven't put on any evidence whatsoever. And we know of none to suggest that African Americans are more disabled or disabled at a higher rates than whites. And so this doesn't feed into their disparate impact claim. The reality is Mr. Holmes has far more of an opportunity to vote in North Carolina than he would if the North Carolina General Assembly had just picked up the law that the United States Supreme Court in Crawford had said was okay and put it into place. There was no free ID there, and there was no excuse for not complying with a photo ID requirement in Indiana. So the General Assembly has created an array of options for someone like Mr. Holmes to vote. Before turning to the Arlington Heights factors, I'd just like to make a couple of legal points. We heard about the Court of Appeals decision in this case, but they didn't have the benefit of a full record. The reason there was a remand and that we've had the last 3 weeks of evidence is because the Court of Appeals decision was not a final decision on the merits, and they wanted the development of the record. And the record is now very different than it was when it was before them. They didn't have Senator Ford's testimony that he was focused on the least sophisticated among us and took steps to ensure that all would be able to vote if they were registered voters. They didn't have before them the evidence from Dr. Quinn that the amount of disparate impact that plaintiffs allege has been cut in half from 589 to 824. They didn't have the evidence that of the 184 ballots that hadn't been counted under 589, most of them would count under 824. They didn't have the comparative analysis showing that North Carolina has one of the most generous voter ID laws in the country. They didn't have before them, the Court of Appeals didn't, the evidence from Senator McKissick's website, where he said there was rampant voter fraud, and that SB 824 addressed that rampant voter fraud. They didn't have the evidence before them that Professor Louloudis provided of tens of thousands of non-citizens living in this state and scores of them voting in an election. And so the Court of Appeals decision is not binding on this court, and this court should assess the evidence before it and make its own determination. The parties are also now in agreement that a specific and essential part of the Court of Appeals analysis doesn't apply. The Court of Appeals held that, quote, "It is eminently reasonable to make the General Assembly bear the risk of non-persuasion with respect to intent." And now the Fourth Circuit Court of Appeals has since refuted and rejected that proposition. And plaintiffs' counsel said at the beginning of this case that plaintiffs are, quote, "not asking the state to bear the risk of non-persuasion with respect to intent," close quote. And
let me just, I hate to to stop you right in the middle of a sentence. I was trying to raise my hand there and
Sorry.
it's okay. It's 10:15, time for us to take our morning break. We're going to take about a 15-minute recess at this point. We'll come back at 10:30.
Thank
All right.
you.